I'm Gordon Thompson. On July 11, 2016, the Arizona Supreme Court held in a case State v. Cisco II that the odor of marijuana alone may establish probable cause for the issuance of a search warrant, notwithstanding the fact that Arizona has passed the Arizona Medical Marijuana Act. The facts are, in the case, the police officers responded to a tip of a strong odor of fresh marijuana emanating from a storage warehouse. When the officers approached the storage warehouse, they could smell what they described as an overpowering odor of fresh marijuana. After determining in their minds that it was coming from a particular storage unit, the officers sought and obtained a telephonic search warrant for that unit. They searched the unit and no contraband was found within that unit. However, based on the odor that they smelled during the search of that first unit, the officers obtained an amended search warrant for the search of a nearby unit, a second unit. In the search of the second unit, the officers found and seized contraband, including marijuana. The defendant was identified as the occupant or owner of the second unit. The defendant was arrested and charged with several crimes, including the possession of marijuana for sale. There was no evidence presented that the defendant possessed an Arizona medical marijuana card. When the case was in the trial court, the defendant moved to suppress the use of the contraband evidence, arguing, among other things, that the odor of marijuana is no longer alone sufficient to establish probable cause in light of the Arizona Medical Marijuana Act. That act authorizes persons to possess and use marijuana as long as they have been granted a card by the state of Arizona to do so. The trial court denied his motion to suppress. The defendant then went to trial and was convicted and sentenced to prison. The defendant then appealed to the Court of Appeals, and in their decision, the Court of Appeals held that the trial court's denial of the motion to suppress was error, and they reversed the conviction. The Court of Appeals held that because of the Arizona Medical Marijuana Act, the mere scent of marijuana by itself is insufficient evidence of criminal activity and cannot be used to establish probable cause for the issuance of a warrant. Again, if that's the only basis, namely the odor of marijuana. The prosecutors then appealed to the Arizona Supreme Court, and in their decision, again issued on July 11th, they reversed the Court of Appeals' decision. In doing so, the Supreme Court held that the odor of marijuana suffices to establish probable cause for the issuance of a search warrant, notwithstanding the passage of the Arizona Medical Marijuana Act. In doing so, they emphasized that possession of marijuana remains a crime in Arizona. They did say, however, if other facts would establish that the owner of the property to be searched did in fact possess a Arizona medical marijuana card, and that information was available to the police before they searched the unit or obtained a warrant to search the unit, then that would not be sufficient to establish probable cause, because in that case, then it would be evidence that it was lawfully possessed. The court said in its decision, probable cause requires only a probability or substantial chance of criminal activity, not the actual showing of such activity. Therefore, innocent behavior frequently will provide the basis for the issuance of for the showing of probable cause sufficient to establish the need to issue a warrant. The court said the odor of marijuana in most circumstances will warrant a reasonable person in believing that there is a fair probability that contraband or evidence of a crime is present. However, the court did say that if the defendant does produce a valid medical marijuana card before the request for a warrant is made, that is a factor which must be considered, and so for a cardholder, probable cause for the issuance of a warrant must exist from factors other than simply the odor. So in short, if the police know the person's a card holder, they can't get a warrant solely based on what they believe is the odor of marijuana coming from that person's property. Otherwise, they still can. Lastly, the Supreme Court said that this decision may well be different if in the future Arizona passes legislation, which is now pending in an initiative, to legalize the possession of marijuana. Lastly, in a companion case, State versus Cheatham, issued on the same day, the Supreme Court held that the search of a vehicle, which was based on the odor of marijuana coming from the vehicle, was justified, again, notwithstanding the Arizona Medical Marijuana Act. If you'd like to read these decisions on this video, there are links to both of the cases.